Here it is. Hello?
Hi, is this Stephen Carlson?
It is.
Hi, it's Nicole Krelik. I'm going to add you to conference.
Did you get my message?
Yes, just hold a second. Ms. Phillips, are you there? Yes, and I have Mr. Stephen Carlson on the line. I'm recording this, and this is Human Services Judge Nicole Krelik. Today is August 24th, 2017. It's 10:30 a.m. This is docket number 196240. This is a pre-hearing conference to determine jurisdiction and determine what the issues are, and to see if we're going to proceed to an actual evidentiary hearing. Present are Mr. Stephen Carlson, who is the appellant, and then, or the appellant's representative. I believe he's representing Victoria Carlson.
Yeah, and Victoria's here too.
Okay, great. So Stephen and Victoria Carlson for the appellant, and for the agency, I have Ms. Ebony Phillips for Ramsey County on the line. So like I said, we're not doing a full hearing, and I'm pretty sure, Mr. Carlson, I had my paralegal call and explain that.
No, you don't even have my number.
Okay, I don't know. I left a message. I
No.
got a message and I sent an email.
Well, I didn't hear it. I'm sorry.
Situation, sir. When I schedule a telephone hearing, we do a telephone hearing, right? If I schedule...
No, ma'am. No, ma'am. There is a law, which is subdivision 10 of 256.451. That's the hearing rules. And I have the right by law to request it. And then everybody has to be present. They can't do like they did last time, sit on the phone. That's the Minnesota law.
Okay. Well, sir, let me tell you this. For actual hearings, you do have the right to an in-person hearing.
Okay.
Or we could do it by video conference. That actually is...
Okay, we agree.
However,
Yep.
first we have to get to the point that we understand. Because what I'm hearing is this is why we're having this pre-hearing conference.
Okay.
Check in to figure out what the issues are. Because it's my understanding that there was already an issue about that Ms. Carlson is not eligible for medical assistance and BC, and therefore now there's a renewal due, and that apparently the issue is the agency is trying to figure out if Ms. Carlson be eligible for MA with a spend down. However, the appellant is saying that we don't want to figure out, we don't want to do the renewal.
Okay, how did you reach that understanding, Judge?
By looking at some information from your notice of action that you received.
Okay, so looking at the notice of action from the county.
Mr. Carlson, what is your issue? What are you trying to appeal?
Okay, well, first of all, I want to say that Brenda Kiepert Holthaus, you know her? She's an attorney in the commissioner's office. She's reached out to us and said that this hearing will take place by statute, and that the determination from the previous hearing on the first date, which was April 23rd, is not final because we filed and served a notice of appeal on Monday, August 21st. So we've made a submit. Yes?
I'm asking you a straightforward question.
And I'm giving you my answer.
Well,
Okay.
that doesn't make any sense because you're talking about a previous appeal that's been already. I looked the record and it looks like.
You know,
when you requested redetermination and that request was denied.
I'm sorry. I am.
Can't file a new
Okay.
appeal.
Okay, I'm trying to answer you, and I'm simply notifying you that Brenda from the commissioner's office, who is an attorney, reached out to us with an encrypted message that I have a copy of that said that this hearing will take place by statute. That's what she said. And now we made a submission to this hearing. Now let's see. Let's go straight to this. I want to touch on the fact that we're talking today because Judge Longfellow, who presided over the first hearing, April 23rd, found that the county had failed to provide us with adequate notice before they deprived Vicki of medical assistance. So in fact, there has not been a previous hearing because there's been no adequate notice. Now that's a due process requirement that's based on the 14th Amendment, the U.S. Constitution, which governs both state actions of Minnesota and its subdivisions, including Ramsey County, as well as actions taken under color of law. And this action challenge is related to the actions of the state and of the county taken under color of law and officials acting under color of law. And those actions dated October 5th, 2016, this is the previous thing you're talking about, were simply to cut off all Medicaid to Vicky. And according to their records, they have paid nothing past November 30th of last year. Now, there might be a few payments they have made in late June of this year after Judge Longfellow's ruling, but after it was adopted by the Commissioner's office. But as far as we're aware, that's all. And after the Commissioner accepted Judge Longfellow's recommendation on June 8th, the county issued another notice of action, and we filed an appeal of that. We did request that benefits for Vicky remain in place during this appeal as well. So Judge Longfellow has instructed the county to try again, to try to meet the state law's requirement of giving us adequate notice so we would know what they're doing. And actually, it should be what they're proposing to do, but they just went ahead and did it with no notice. And we are supposed to have a chance to talk about it before they carry out that proposed action. And Judge Longfellow, in her recommendations adopted by the Commissioner, now she's talking about transferring Vicky from MABC, Medical Assistance for Breast Cervical Cancer, to an elderly program, which is not a cancer treatment program and requires a spend down, which Judge Longfellow said effectively bars Vicky from receiving any Medicaid dollars for her medical care during the course of her cancer treatment. So let's be very clear on what we're saying here. We're saying the county, through their notice of action, which we challenge here, is now proposing a change, and that change is a decision affecting changes in methods and procedures of payment. And again, they don't propose, they just act. They have already again deprived Vicky of any Medicaid dollars. But I think we can all agree here that this proposal by the county, if adopted, would definitely be a decision with the action already taken affecting changes in the methods and procedures of payment of Vicky's Medicaid benefits. And I'm going to show you that mandates of changes in methods and procedures of payment must be consistent with the principles of economy, efficiency, quality of care for Vicky, and equal access to Vicky. And a big issue here is whether the changes proposed by the county, and again, I need to say they already carried out that plan last October. Apparently they and other Minnesota counties do this for hundreds of women in the state. Now, that is a decision affecting payment of services, and it is not at all consistent with the principles of economy, efficiency, quality of care, and equal access, all for Vicky and her cancer care, which she's entitled to. So obviously it's not. So I'm speaking specifically of this transfer, which Judge Longfellow instructed the county to give us adequate notice of, so we could have an opportunity to discuss and to contest it here. And to be clear, they're trying to do again what they already did in October because of the fact that Judge Longfellow tried to undo some of what they did in her recommendations. She reversed their actions adopted by the Commissioner. That was because basically what the county did in October didn't make any sense. And they failed to give adequate notice to us what they were going to do so we could have the opportunity to be heard in a face-to-face hearing and contest it. And while I'm on the U.S. Constitution, we protest not being able to discuss our rights and Vicky's rights under the Medicaid program that are secured for us by the U.S. Constitution. I've addressed the 14th Amendment, and these same rights apply for the 5th Amendment, protecting us against violations by CMS and Congress, if that had occurred. And according to my research, the federal government gave these rights to Vicky and is not trying to take them away and replace them with this spend down, which bars her from any Medicaid dollars. And so the federal law and policy supports Vicky's right to receive Medicaid, paying the balance of what Medicare will not cover to the end of her treatment. So the due process clause, the clause against arbitrary and capricious decisions and actions by the county, which this is another example of, the protection of privileges and immunities of all U.S. citizens, which Vicky is, and notably the right to age in treatment. That is a civil liberty to age in treatment, and the county violates it by penalizing her for attaining age 65 while in cancer treatment. But the government is constrained from penalizing her as a recipient of this treatment, and that's a violation of the Constitution. And then there is the Equal Protection Clause that's violated here. As I've said, they've created a suspect classification of age within the people in the program, and they damage and they take malicious action against them, and they have no compelling state interest for that. And it also doesn't even have a rational basis, which is the lowest standard of the equal protection, because you're giving money to people and taking the treatment away, which means that the money is being wasted. And the reason I try to present these constitutional issues, even though the state legislature has passed a law saying her constitutional rights may not be protected in this administrative appeals hearing, is first to raise a protest against that state law for violating the U.S. Constitution. And as Judge Longfellow stated, even though the Human Services judge may not entertain them, she may still comment on such issues as due process through adequate notice, as Judge Longfellow did. But
Mr. Carlson, I want you to back up, because you're kind of getting into the argument you would make at a hearing, and I'm really just trying to figure out the issue. So what I hear you saying is that you disagree with the determination that that Vicki Carlson is not eligible for MA under the breast cancer program.
what I'm saying is,
As you continue to argue your points about that, you want continued benefits for her on that program.
what I am saying is that we have not yet had the fair hearing, which under state law, and by the way, this is also required under federal law, because she's asserting a claim. I believe this is of 1396A, I believe it's A3.
You're arguing, I need to understand, so I'm sorry for interrupting you, but you're arguing that the hearing that you had in front of Judge Longfellow wasn't correct under the law, and therefore you want that looked at again.
Well, she herself,
You want to have a different hearing on the same issue with a different judge.
it's not, no, it's not an issue of the same issue with a different judge. They are proposing a whole package which we never knew what it was for that hearing. And the judge has admitted, and she's concluded, and the commissioner knows, that there was not adequate notice of that hearing. Adequate notice means what they are proposing.
What are you talking about? What hearing did you not have adequate notice of?
First of all, this one, because they still didn't say what they propose and what are the grounds. And
You know we had a hearing now. You got a hearing notice in the mail. That's why you called me.
yeah, well, I'm not in a hearing yet. But I'm saying, notably this one, but that one, we also were not given the proposed action. The hearing.
What is it that you did not have at your last hearing that's bothering you specifically?
Adequate notice where it said.
Notice of what though? Notice of the hearing? You didn't get your summary? Like what did you not have?
The adequate notice was, so are you thinking of overruling what Judge Longfellow said and saying that there was adequate notice and there was due process?
I'm trying to understand what you're telling me.
Okay.
I don't understand what you're saying. I'm not making any decisions here. I'm just trying to clarify the issue. That's why we're having this pre-hearing conference. You know what? I'm going to ask you to step back for a moment, and I want to hear from the agency, and then I'll give you an opportunity to respond, okay? So, Ms. Phillips, can you fill me in here? Maybe you can illuminate me a little about what the issue's going on here. Well, from everything that I'm seeing, and I'm getting lots and lots of documents from Mr. and Mrs. Carlson. Yeah. I have a document that I'm just getting
Thank you. Well, first of all, I would want to point out that she said that she doesn't know anything about the federal law, and she said before she doesn't know anything about the state law. And yet, her job is to administer those laws. Now, this is a very special program. I don't know if either of you are aware of it, but this is a federal program. It's not, it's an optional program that's been adopted by...
I'm familiar with MABC. I'd like to hear you respond to the issue and tell me if you disagree.
Yeah, well, it's a very unique program. It's a life-saving program that's been cut off during treatment. And to me, that is a very relevant fact. Now, as far as what she said, she admits she does not know the federal law or the state law. What we need is, if an action's going to be taken, they have to tell us what it is, and they have to be very clear, telling us the federal applicable law and the state law, so that we can discuss that. That was never done, and it has never been noticed. Are you familiar with the first October 5th notice of appeal that didn't give us adequate notice? It was saying that she had been, since July of 2016, requiring a spend down, and that she failed to provide bills over and above the spend down that she had. And the judge concluded she didn't have any spend down, and she wasn't on that program, and so that's why it was inadequate notice. Now, she said she just took it over. Well, that doesn't hide the fact of what the first hearing was about. And in the middle of that hearing, the judge and her still couldn't figure out what they had done. She said, I don't know why we did that. I don't know why we haven't paid the benefits during this appeals process. I'll have to look into that. And that was called a hearing. Now, the fact that Judge Longfellow did go ahead and issue some recommendations, one of those findings was that it was not adequate notice. Now, we have a constitutional right. This is from the United States Constitution. This isn't just give us MA. Can I say this because she said that? That is very, I want to say this very politely, but that is very mean and wrong to say that all we're trying to do is get something that Vicky isn't entitled to. Now, we can get into the merits of it. What I would suggest is this. If she feels that strongly that this is the appeal summary from the point of view of the agency, I would like her to put that in the form of an agency appeal summary and mail it to us so we can have this very discussion. Now, you're saying that, well, some element you think has already been decided. Well, first of all, it wasn't before the judge in that hearing. What was there was the October 5th hearing. The October 5th notice that all Medicaid was to be cut off because she hadn't turned in spend down documents, which she wasn't supposed to. And it was totally irrational what they did. So they can't just, out of a big chaotic mess, isolate one thing that they feel has already been decided, even though everybody knows that it was not put forward in a way where people can know what the issues are and present their case, which is in the rules. So this hearing has to follow those rules. Now, I would argue still that they should put in their appeal summary, and they should have put in their notice of action what the proposed action was and what their grounds are. But instead what they said was, well, just we would refer you to this recommendations from the judge in the hearing. Well, that is not notice. If they don't know well enough why they feel they can do what they are proposing to do, whatever it is, which is basically to bar her from all Medicaid. That has never been decided, that hasn't been argued that she's going to be barred from all Medicaid. Now then they say, well, if you turn in something, we're talking about Medicaid on the basis of being a breast cancer patient, still in treatment. There's no way that that is allowed, okay? And do I disagree with it? Absolutely I disagree with it. But we want due process where we look at the totality of their action, taking not only that program away, but barring any Medicaid dollars that would normally be. The details are set out, and they should be allowed to proceed, and they're not stopped by the fact that what we did, and I mentioned Brenda at the top. She is the lawyer. I don't know why she reached out to me, but I had been talking to Andrew Johnson, and because Emily Piper had reached out to me on Twitter. And she referred me to Andrew, and finally Andrew referred me to Brenda, and they looked into this, and they said this hearing will go on according to statute, and the case still needed to be filed because of the nature, the wrongful nature of the Longfellow and Commissioner's action, which is basically to say, okay, we haven't had notice, okay, but we're going to still act. So you have to have notice, and these are our rights. You have to give us our rights, or we'll be talking about them a long time.
Because we have run out of time.
Okay.
I understand what you're saying.
Mm-hmm.
I do understand what you're saying. So this is what's going to happen. I'm going to end this conference. I'm going to make a decision as to whether or not there's jurisdiction. And you will, if there is, we will set a new hearing, an in-person hearing. And if not, you'll get an order
All right.
about that.
Let me ask you this. Jurisdiction. What jurisdictional statute is the county arguing on, and what jurisdictional statute are you looking at so that we'll be aware of it and we can study that and have input into that decision?
It's a double docket.
I'm sorry, what? I know, but what
It's a double docket. Have these issues already been litigated?
what is the jurisdiction? That's not jurisdiction. That's res judicata. I'm asking you, what is the jurisdictional authority which you're pointing to which would limit the jurisdiction? Can you tell me or not?
There's a statute involved.
And what is the statute involved so that I can...
I'm going to end the hearing, sir.
All
I
right.
have another hearing scheduled. Thank you for your